This We the People News. Not attorney, not giving legal advice. Education purposes only. Never look straight forward, always look around you. Be able to protect yourself by any means necessary. Arm yourself with knowledge, people. People, 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 people. Let's get this through our heads. Men and women, men and women, men and women. Okay? Quit bowing down to them. Stand on your Constitution protection, right? They say it's protection for us, but no. It's technically a no trespass upon the men and women's rights. Okay? So we also need to tell them they're trespassing. They're trespasser. All right? And they're committing domestic abuse against us. Okay? Also, one of the people can be citizens, but it's capital C, grammar. Okay? And the lower key, citizen, according to the law of nations, right? That lower C, citizens, is the government people, all the government bodies, okay? They are citizens, okay? We are people, and we may be classified as citizens, but it's the capital C citizens. But why do we need to classify ourselves that anyway? All we have to know is we're one of the people, all right? And we have political powers over our, I don't want to say subjects, but, what are they called? Servants, right? Uh, we don't want them to be our subjects. We just want them to be our servants, and they want to be good little boys and girls, okay? And we need to start learning how to file criminal complaints, take it to the magistrate, and let them know we're not joking about this when they violate your rights, okay? Quit filing complaints and take it to the people who investigate themselves. That's that defeats the purpose. Every now and then you may get something out of it, but even worst case scenario, you would actually have to file 7 complaints to even affect their insurance. Okay? And I don't know why it's doing that. Let's see here. Alright? Just nip it in the butt and actually figure out what you're going to do and use that statute, Constitution, and an oath against them. Right? Texas is Criminal Code 39, which holds government, judges, our legislatures, and cops, and all them, is one of the only states I know of that actually has a code that's specifically designed, and it's a felony. So for us, that's a good thing in Texas, especially how corrupt Texas is. Here's part 2.
Judicial action without jurisdiction is void. Where the court is without jurisdiction, it has no authority to do anything other than dismiss the case. Judicial action without jurisdiction is void. And that's a couple court cases that support it. Idaho statutes are void for vagueness. And this is true. Think about it. You know, what they're doing is they're assaulting you with a quasi-contract, okay? Any penal code is a quasi-contract. And they're not telling you that this is a civil matter. They're calling it a criminal matter. And they're assaulting you and making you put up bond and all sorts of crap. And they're not telling you it's really a civil matter. Anyways, so the statutes don't say who they apply to. Listen, he goes through and explains it pretty good here. John Smith alleges that laws are overbred or void for vagueness if they impinge on or chill any constitutionally protected conduct, substantial or otherwise. John Smith alleges that this is a court that enforces all laws on all people all the time, even though this court is deemed to know that not all people are subject to the jurisdiction of this court or all the laws codified in the Idaho statutes. In fact, there's reason to question the authority of even a judicial branch court to enforce violations of the state statutes on people such as the alleged defendant, because the Idaho statutes are not the actual laws of Idaho. Yep.
Don't tell me that's a gut punch. That is absolutely a gut punch. to the judicial branch, right? You're calling them out on the crap they're pulling.
It's dependent further alleges that due to the ambiguous format in which Idaho statutes are written, they are void for vagueness. So vague, in fact, that they cannot be deemed to be public writings. As such writings are required to be written in such simple language the average person can easily read and understand them.
I mean, you had to say, this is brilliant. Okay? Again, y'all, if you guys do it, I would do the absolute vague and ambiguous, absolutely. You know, and it just gives that another, uppercut. This is brilliant. I really enjoy this, as you can tell.
The Idaho statutes do not, in clear and easy to understand terms, differentiate between A, those that only codify laws that only apply to United States citizens and foreign aliens in a state, and B, those that codify laws that also apply to those like the alleged defendant who are only citizens of a state. And that's true. They don't differentiate. They're vague. And this is a court case, U.S. Supreme Court. It is a basic principle of due process that an enactment is void for vagueness if its prohibitions are not clearly defined. Vague laws offend several important values. First, because we assume that man is free to steer between lawful and unlawful conduct, we insist that the laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, so that he may act accordingly. Vague laws may trap the innocent by not providing fair warning. Second, if arbitrary and discriminatory enforcement is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis with the attentive dangers of arbitrary and discriminatory application. Third.
Now, for that Supreme Court, just in case you cannot read it on my thing because I have a sucky camera, it's Gray NED versus City of Rockford. All right. CITY of OF, obviously. Rockford, obviously. ROCKFORD. All right. And it's 408 US 104 dot 108/109 1972. And I have not read this case, but I suggest you look it up and read it and all that kind of stuff, verify what it's saying. But that's a very strong case, y'all. Very strong. That's another sucker punch or an uppercut. But I had to classify as that's a sucker punch.
But related, where a vague statute abuts upon a sensitive areas of basic First Amendment freedoms. It operates to inhibit the exercise of those freedoms. Uncertain meaning inevitably leads citizens to steer far wider of the lawful zone than if the boundaries of the forbidden zone were clearly marked. And this is a Ninth Circuit case. Due process requires statute to be sufficiently clear so as not to cause a person of common intelligence necessarily to guess at its meaning and to differ as to its application. Related to, but
not to guess. Let's clear that up, right? It's not to guess. It's got to be clear, people.
From the vagueness doctrine is the doctrine of overbreadth. A law is overbroad if it prohibits not only acts the legislature may forbid, but also constitutionally protected conduct. Considering there are two completely independent classes of citizens in the several states, addressed further down, When the Idaho statutes are taken as a whole, it's impossible to discern which statutes apply to whom, thus causing those people that are only citizens of their states to refrain from conduct the Idaho Constitution secures as a protected right for them to engage in. Alleged defendant alleges that the Idaho statutes are both void for vagueness and overbread when they are imposed upon those people like the alleged defendant, which are only citizens of their state, because in plain language they do not give sufficient notice to the state-only citizens like the alleged defendant, and the police or judges what conduct is criminalized and what is not, thus causing individuals to defer from engaging in conduct that is constitutionally protected, and subjecting state-only citizens to unpleasant forced police interactions and prosecutions for constitutionally protected conduct. John Smith alleges that the Idaho statutes, when imposed on those people that are only citizens of their state, such as the alleged defendant, operate to criminalize constitutionally protected conduct. John Smith therefore denies that the statutes can be used in a charging instrument for people like the alleged defendant, who are only citizens of their state. So the charging instrument's defective. There are codified within the Idaho statutes those laws that the state legislature is authorized by the state constitution to make and impose upon those people, like the alleged defendant, that are only citizens of the state, and which enforcement can only be accomplished by a judicial branch court. And
I mean, oh my gosh, y'all, that is so powerful, because judges, when you go into even with the higher courts and get out of the magistrates, right? Well, they have a tendency to still actually waive the judicial judge immunity and still put themselves into administrative, which waives their judicial immunity. Brilliant. Okay. I'm sorry. This is just brilliant.
B, there are those laws codified that only apply to citizens of the United States and foreign aliens in the state that are administrative in nature. The majority of the statutes comprise laws that only apply to citizens of the United States and foreign aliens in Idaho, which can be enforced in a legislatively created municipal court. John Smith denies that the Idaho statutes clearly differentiate between those codified laws that apply only to citizens of the United States, foreign aliens, and people like the alleged defendant, which are only citizens of Idaho. John Smith further alleges that the Idaho statutes are void for vagueness when it comes to the alleged defendant. Paragraph 5, or Chapter 5, This court enforces all statutes and recognizes none of the limitations imposed on judicial branch courts when enforcing laws upon state-only citizens such as the alleged defendant. This fact alone is enough to prove that this is a municipal court and must see all before it as federal citizens and foreign aliens. The plaintiff in your court is a municipal corporation called State of Idaho, and not the people of Idaho. The representative of the plaintiff is a district attorney, a corporate attorney for the state of Idaho, not a public prosecutor as constitutionally required to prosecute a state-only citizen like the alleged defendant.
Again, y'all, really sit and think about listen to the words, and listen to this 3 or 4 times maybe, and these words that he's using is just, he's kind of a martial artist, UFC. I haven't watched it in such a long time because of research and all that, but he's got a rear naked choke, and he's on the back of the people right there, on that back of the judge, and putting that judge in a rear naked choke. That judge is fixing to pass out.
Your court only recognizes the due process rights accorded to citizens of the federal government It does not recognize the due process rights of someone like the alleged defendant, who was only a citizen of the state. For instance, your court does not recognize the right to a jury trial, much less a trial by jury, as mandated by the Idaho Constitution for someone like the alleged defendant.
And some of you guys have been with me a long time, right? I've told you guys over and over, all right? Jury trial and trial by jury is two different jurisdictions. It's two different jurisdictions. There's just no ifs, ands, or buts about it. Jury trial is Roman civil law. Trial by jury is common law. And he's, again, he's challenging it. And, you know, he's still on the back, and he still got the judge in a rear neck choke.
I'll be back in a second.
So good.
All right. We're going to go ahead and leave it here. I may, just because it's so good, I may go with part 3. Just with People News. Bye, y'all.